cop lies under oath, and it backfires instantly.
You stated to the jury that you observed Mr. Martinez chewing gum.
That's correct.
Look through your offense report and point out the place anywhere in there where it says that you observed Mr. Martinez chewing gum.
No, I didn't have it to my report, no, sir.
It's because you didn't notice that.
This officer thought he could lie under oath and walk away untouched. But the moment the defense attorney laid out the facts, his entire story collapsed in front of the entire courtroom.
Really?
Yes, sir.
Officer, you didn't even know he had gum in his mouth. Where is it in your offense report?
What happened? Well, it was a normal night in Houston, Texas, when a police officer spotted a car speeding down the road. Behind the wheel was a man named Mr. Martinez. The officer pulled him over for driving above the speed limit.
I think you said you're out there looking for speeders and also drunk drivers.
Yes, sir.
So you were like the speeding and drunk driving enforcer.
Yes,
You're
sir.
looking for people to arrest or pull over for DWI, right?
Correct.
Nothing about Martinez seemed dangerous or suspicious. Like a good citizen, he immediately turned on his blinker, safely pulled over, and already had his license and insurance ready before the officer even touched the window. He was calm, polite, and cooperative.
You were going to ask him for that, right?
Yes, sir.
How in the world is that a sign of intoxication? You said he was bouncing it?
Yes, sir.
That's a sign of intoxication.
There had been no calls about a drunk driver that night. Nobody reported reckless driving. At that point, this looked like a simple speeding stop. But here's where it got super fishy. When the officer walked up to the car, he claimed he smelled alcohol. He asked Martinez if he had been drinking, and Martinez admitted he had a little bit to drink. The officer then asked him to step out of the vehicle and performed a field sobriety test. Martinez refused.
People have the right to refuse those tests, right?
Correct.
And he invoked that right.
Under Texas law, that is nowhere near close to enough for a DWI conviction. The law requires the state to prove one of two things: that the driver's blood alcohol content reached 0.08 or higher, or that the alcohol genuinely took away their normal mental or physical abilities. A smell and a confession to having one drink do not meet either standard. The officer knew this. However, instead of closing his notebook and writing a speeding ticket, he decided to act beyond his authority.
He thought about it. He made a conscious decision and said no, right?
Yes, sir.
Which he has the right to do.
Yes, sir.
You intended to perform those tests, as you stated, to determine if he was intoxicated or not, right?
Correct.
The officer arrested Martinez for DWI. Months later, the case went to trial. During the trial, the officer took the stand and confidently told the jury that Martinez admitted to having a few drinks. At another point, he even described it as several. He also claimed Martinez showed different signs of intoxication during the stop. Then, the defense attorney stood up immediately. The cross-examination was calm, patient, and methodical. The attorney did not shout, he did not accuse, he simply asked questions and let the evidence answer them.
You wrote in your office report, right, that you asked the driver if he had any alcoholic beverages, right?
First, he asked about the drinking admission. The attorney pointed to the officer's own written police report filed closely to the time of the incident. Well, what did the report say? It said Martinez stated he had one drink. The officer even wrote the word "one" out in full and put the numeral in parentheses as if to make absolutely sure there was no confusion.
What did you write? He had only one, and you put O-N-E, and then you put parentheses and the number one in there to make sure that there was no, you never wrote anywhere that he had a few or several, or that he came back later and said, well, honestly, I have more to drink. Is that anywhere in there?
No, sir.
The attorney then played the dashcam footage in open court. The officer sat on the stand and tried to hold his position, suggesting that Martinez had said, honestly, yes, at some point on the video, as if that meant something.
There's a part of the video where he says, honestly,
He said,
yes. Honestly, yes.
yeah.
Oh, yeah.
Well, that's why I wanted to show you what the state showed you.
The attorney pushed back without flinching, offering to replay the footage as many times as needed. Eventually, the officer was forced to admit that Martinez never said a few. 3 versions of the same moment. The report said 1, the video said a little bit, the officer's testimony said a few or several, depending on which part of the testimony you caught. That alone would have been damaging enough, but there was more. The attorney moved to the officer's physical observations, the things he said he noticed that pointed to intoxication.
You stated to the jury that you observed Mr. Martinez chewing gum.
That is correct.
The officer claimed he observed Martinez chewing gum, which he suggested Martinez was using to mask the smell of alcohol. A classic tactic on paper, except the attorney went through the police report line by line and found no mention of gum anywhere.
Look through your office report and point out the place anywhere in there where it says that you observed Mr. Martinez chewing gum.
Well, I didn't have it to my report, no, sir.
It's because you didn't notice that.
Then he pointed to the dashcam footage. At no point during the initial encounter did the officer notice gum. It was a second officer, Officer Potts, who later noticed it, asked Martinez to open his mouth and told him to spit it out before getting into the patrol car. The arresting officer had taken a detail spotted by someone else after the fact and presented it to the jury as his own first-hand observation of suspicious behavior, under oath.
Really?
Yes, sir.
You didn't even know he had gum in his mouth. Officer Ponce comes out. I mean, eventually you did, because Officer Ponce told you, right? Where is it in your office report? Show me. Just show me. Where's it on the video that you observed gum in his mouth?
The attorney also challenged the officer's claim about how Martinez pulled over. The officer testified that Martinez straddled the yellow line when stopping, implying this was a sign of impaired driving. The attorney pointed out that the officer never told Martinez where to pull over, that it had been raining, and that a second officer actually arrived and helped block the lane to make it more safe, suggesting that the stop location was not exactly alarming to anyone on the scene.
Did you get on your bullhorn and say, driver, pull over to the right shoulder?
No, sir.
You could have, right?
Yes, but due to the
Yes?
rains, say yes, sir.
Then came one of the sharpest moments in the entire cross-examination. The officer had cited various signs of intoxication during his testimony, referencing his training under the National Highway Traffic Safety Administration, the federal agency that sets the national standard for how officers identify drunk drivers. The attorney noted that speeding, the very reason Martinez was pulled over, has never been listed among NHTSA's recognized indicators of intoxication. The officer was using observations that were not backed by any official training standard to justify arresting a man.
But also a whole list, a litany of signs about how a person's driving that could also indicate intoxication, right?
Yes, sir.
100 different clues they list that say if a person is driving like this, that could mean they're intoxicated.
All right.
Did you know that speeding has never been one of those signs?
By the end of the cross-examination, 3 pillars of the state's case, the drinking admission, the physical observations, and the officer's credibility, had all been knocked down by the officer's own words, his own report, and the video recording he apparently never watched before taking the stand. Judge Fleischer ultimately granted the motion to suppress, ruling there was no probable cause for the arrest. Every piece of evidence collected after the arrest was thrown out with it, and the state's case collapsed entirely.
Well, I motion to suppress the arrest. No probable cause. I mean, I think there's no credibility at all with this.
I'm going to grant it. I'm going to grant this motion.
In the end, the officer's entire case fell apart because the evidence simply did not match his story. What started as a routine traffic stop turned into a courtroom lesson on why honesty under oath really matters.